You requested a testing of the weapon. So everybody knew about this weapon. And I said that both parties have been diligent on doing this. And then the defense was to file a motion to allow for testing of the weapon, which I'm assuming you did and the court signed.
We didn't need to, Your Honor,
Yeah,
because
well,
our
well, just-
expert advised he didn't need it.
And then it says defense expert has no lab, will seek outside lab or state lab for testing. So you all had this information, unless there's a different gun, everybody had this information from October 10th.
Court Uncut, what the people want.
All right, this is scheduled for jury selection on Friday. Why are you all here? What motions do you have?
The state filed just a motion in limine, Your Honor, just for a few things. I don't know. It was filed this morning, so I don't know if defense has had an opportunity to view it.
I've not received service of it, Your Honor.
All right.
Mr. Goldstein advised me just by telephone about 2 minutes ago that he saw that it had been filed, but I don't believe he's read it either.
All right, so
I was unable to open it, Your Honor. My apologies.
no problem. With regards to motions and limines, I do not know anything about this case. So as far as me ruling on any motion and limines, unless it's something that's specifically in case law where it's not allowed, then of course the court will make its ruling. But if it has to do with whether or not certain questions should be asked or whether or not certain evidence should be presented, y'all will need to approach prior to going into whatever subject matter you have with regards to motion and limines from the defense or from the state.
And Judge, it's not something associated with voir dire, it'd be associated with the actual case in chief and punishment. So it's not a question of hearing it before we pick a jury.
All right. Any other-
Your Honor, if I may, I'm particularly concerned about a recent disclosure that the state's key witness has given prior sworn testimony before a previous judge in this court regarding our client's participation in this case. And I believe I would like to make sure that we're able to supplement our motion for continuance with state versus.
Just 1 second. Let me finish addressing the state. Are there any other motions?
Not at this moment, no, Your Honor.
All right, defense, any motions?
Your Honor, we filed a motion for continuance back on January 24th, and I informally had advised the court of the fact that that was a concern. Let me update the court since then, because there will be need for us to supplement.
All right,
because
and
of its
before
verification.
everybody updates me on the supplemental as it relates to the motion for continuance, let me ask everybody a question. Did I not ask you all what date you all wanted for jury trial? I had given everybody continuances before. People wanted to go on vacation or trips with their family members. I let them go. I said, talk to the coordinator and choose a jury trial date. Is my memory faulty or is that what I did?
Your Honor, let me, if I could give.
Well, no, we're gonna get to that. But did I do that?
Yes, sir.
Yes, Your Honor.
Did you all choose this date as your jury trial date?
Yes, sir.
Did
Yes.
you all choose Friday as the date for jury selection?
Yes, sir.
All right, and then today was supposed to be for motions. And this was done, I think, back in November. So before I get into your motion for continuance, because I want the record to be clear, this case has been on the court's docket since 2023. We are now in 2025. So May 8th, 2023, this case was set for discovery. It was called back on June 5th, 2023 for discovery. Then it was called back on August 3rd, 2023 for discovery. Then it was called back on October 5th, 2023 for discovery. Then it was recalled on December 7th, 2023 for discovery. Then it was called on January 30th, 2024 for discovery. Then it was set for jury trial. And it did not go to jury trial because there was more discovery. So then we came back on April 2nd, 2024, and it was set for jury trial for October 14th, 2024. Then everybody said, we can't do that. We have vacation, we have this. Then we came back on September 19th. I'm sorry, we were here on April 2nd, 2024. Then we came back on August 27th, 2024. Then it was recalled for September 19th, 2024. Then it was recalled for September 23rd, 2024. Then it was recalled for October 10th, 2024. Then we had the jury trial scheduled for October 14th, 2024. Then we came back on November 21st, 2024, discovery acknowledgement sign. And then we came back on December 2nd, 2024. I told both parties I wouldn't charge a continuance to either side. Then we came back and here we are. So I'd like the record to be clear on what is happening in the case. So now I'll hear your motion for continuance.
Yes, Your Honor. With respect to the court's recitation of the history, I think it's important that we make clear the settings that were held in September of 2024, we had every reason to believe when they were being discussed in the spring of 2024 would hold based upon the production that the defense had already received and based upon the state's representation that apart from jail correspondence, which was of little evidentiary value in the case, no additional discovery would be forthcoming. In July of 2024, the defense, in getting ready for that trial setting and making preparations, found a one-line entry on one page of what is otherwise a very extensive and copious amount of paper discovery, referencing a remark by a detective that he wished that he could also have in his possession ballistics reports done on a firearm that was recovered from Jalen Bell, who is an indicted co-defendant in the case, who has already pleaded guilty and been sentenced to prison. We, based on the discovery, came to the conclusion that no such firearm had ever been tested and that its origin, or its location at that given moment was unknown. We began conferring with Jason Garahan for the state about this matter, and we tried to bring this matter to the court's attention. Mr. Garahan engaged.
Wait a minute. Let me stop you right there. What do you mean you tried to bring it to the court's attention?
We informally approached the court, I believe, on a couple of different occasions to advise that this was a matter of concern, and then eventually we filed
No, are you talking about
motions.
when you filed the motion for continuance?
The original motion for continuance was not the first time that we had made the court aware of the issue, is what I'm trying to avert to. We were concerned almost immediately in late July, early August of 2024 that this was going to be a matter of concern, and we were trying to get to the bottom of what was going on.
But you all picked the court date
Well, Your Honor,
for the jury trial.
yes, and as I'm explaining, that court date was selected sometime long ago. In the course of preparation for that, we found a very, very, very small reference to this firearm in what is otherwise a very, very large amount of evidence. We advised the prosecution of that fact and sent over a draft motion to compel about anything that was related to it. But of course, we didn't need to file or urge the motion to compel because Mr. Garahan, who has been doing an excellent job keeping up with this, was similarly, I believe, and correct me if I'm wrong, not really aware of the firearm recovered from Jalen Bell because previously it had had such little significance.
So you didn't file a motion with the court urging the court to compel any evidence, correct?
We approached the court and advised the court of the fact that we were trying to sort out this discovery matter between the parties, which we did. We sent a draft motion to compel over to the prosecutor, and rather than having to urge it formally to get an order for the production, the prosecutor undertook his own independent steps to locate that firearm.
All right,
That
so I'm just trying to get the record to be clear because I like for the record to be clear.
I'm doing my
Nothing was urged with the court. No motions were given to the court about any other evidence, correct?
Well, in September, Your Honor, I believe we did urge a reset or a continuance based upon this information. But I'm just giving the backstory to the time when we formally discussed resetting the case because of it was not the first time that we had brought it to the court's attention that we were concerned it might cause delays in the process. And I'm further just trying to explain that this wasn't evidence that the prosecutor just had in hand and it was in his file and he just hadn't given it to us. It was information that Mr. Garahan similarly did not have anything more than we did about it at the time that we corresponded. Now, law enforcement involved in the case may have, but it hadn't made its way over to the DA's office with the rest of the discovery.
So that's September, October, November, December,
I'm not quite-
January?
I'm not quite done with the recitation, Your Honor. I do want the record to be clear.
Sure.
So we advised Mr. Garahan of this throughout August and September. Efforts were made to locate this. The prosecutor advised that they had identified the firearm that we were discussing, and they sent it over for ballistics testing. That ballistics testing came at the end of September in accordance with when the court reset this matter for this issue. We engaged an expert witness, Ed Huskey, to conduct his own independent analysis of the firearm. Mr. Huskey advised he would not need a laboratory of his own to conduct that analysis, that he could work off of the bench notes from the firearms investigator for the state of Texas. My records indicate that we engaged Mr. Huskey formally on the 10th of October, but we would have been in discussions with him the week prior. We have sent Mr. Huskey, we believe, everything that he needs to complete his analysis, but Mr. Huskey has advised that he has not finished his analysis. This was the major pressing concern of the remaining settings of the fall, is that we did not have the ballistics analysis. And we believe that this is an extremely material piece of evidence because it goes to the heart of the state's case, which is that Mr. McIntyre was the shooter in this engagement, and that there are at least, there are 4 other individuals in the car besides the deceased. So, and the deceased, just to give a brief summary of the facts, the police that have investigated this have averred that the deceased was ejected from the vehicle or forced out of the vehicle, that he jumped back onto the hood of the vehicle, and that they allege Mr. McIntyre discharged a firearm and killed him. So if, in fact, that firearm that was in the possession of Jalen Bell were to be identified as the firearm, or if it could not be ruled out as the firearm, that would be a material aspect of Mr. McIntyre's defense, and an essential one. So that explains the general landscape. Yes, along the way, there were discussions about scheduling conflicts, some of them of a personal nature with some of the litigants. But the primary thrust and reason why we have been resetting this matter time and again since September has been out of concern for the fact that the defense has been unable to
No,
independently
this has
vet.
been reset since May of 2023.
Yes, Your Honor, and I'm just explaining, we did not discover this information until the time frame that I am letting the court know about. We discovered it at the end of July. Throughout the course of August, we were conferring with the prosecution. In September, we had discussions at the bench about this matter on the record, in which it was established that we needed this information, that it was material. The court granted the continuance on that basis. The state was able to produce for us a ballistics report for this firearm. That ballistics report required us to have to go and independently vet whether the report was accurate, or if there were any reasons that we might be able to cross-examine the author of the report based upon his analysis. And that's what we have been working very diligently to try and accomplish, but we don't have that report yet. In the interim period, at this court's last setting in December, the court asked if discovery had otherwise been fully complied with, and we believe it had, apart from this continuing issue that we've experienced regarding Mr. McIntyre's jail correspondence, which we've now discovered the reason why we've been unable to download that material is because an associate in Mr. Goldstein's office, who's only made 1 filing in the entire case, has mistakenly been placed on the clerk's list as the lead counsel. And as a result of that, neither I nor Mr. Goldstein were able to access from our credentials that e-discovery. However, Mr. Garahan has been extremely helpful with us because the state didn't realize why we weren't getting the discovery either until just a couple of weeks ago. And we have been going over and meticulously getting this information on external hard drives and hand it over to us so that we can process it. It's voluminous, but it is largely not relevant to the litigation. At that setting, the court asked of the state of Texas whether or not it had fully complied with Article 3914, and both parties represented that we believe that it had. Since that time period and since the first of this year, and we've
Just 1 second, let me go back to this expert. According to our last hearing on October 10th, 2024, the information I received from both parties was this. I said neither side would be charged with a continuance. State was unable to have some witnesses appear because of the county budget. You requested a testing of the weapon. So everybody knew about this weapon. And I said that both parties have been diligent on doing this. And then the defense was to file a motion to allow for testing of the weapon, which I'm assuming you did and the court signed.
We didn't need to, Your Honor, because
Well,
our
well, just-
expert advised he didn't need it.
And then it says defense expert has no lab, will seek outside lab or state lab for testing. So you all had this information, unless there's a different gun, everybody had this information from October 10th.
That's what I'm explaining, is that by October 10th, I mean, so we discovered there was a problem in end of July, beginning of August. Throughout August, we were looking for a gun. By the September settings, we were aware that there was a gun.
Yes.
And then the state produced a report. On the 10th was the date that we had engaged formally Mr. Huskey, having conferred with him informally for a week prior. We weren't even sure if we would be designating him as an expert at that time. We, at the time that we had that bench conference, assumed, not being firearms experts ourselves, that it would require Mr. Huskey to have access to the physical weapon and to the laboratory analysis. Mr. Huskey has advised us, and I believe that this is consistent with what I've later learned talking to other people in the field, that it is very common in the industry of firearms and tool mark examination for the examiner to be able to run a preliminary round of review and critique of the methodology and the reliability of the data based solely on the bench notes and the work product of the original firearms investigator, and that we would not need access to a laboratory. That led me to have an overinflated sense of how quickly we might be able to get it done if it was simply a matter of paper review. But it has turned out that that doesn't seem to be the case, and Mr. Huskey has not, as of today's date, given me a final report that I would be able to make use of. In fact, I'm having to essentially designate him somewhat prematurely because I don't have an opinion upon which I can confidently say that I would choose
Have
to
you
call
called him to ask him
Multiple
when he's
times.
available?
multiple
Well,
times.
what's the answer?
Well, he's physically available for the trial, but he doesn't have any
When will he
analysis.
have analysis done?
He hasn't given me a straight answer.
Well, you need to call him and ask, because this case is not going to be sitting out here forever. And this is the court's problem. My problem is everybody comes in here and wants a special setting for trial. I give you a special setting for trial, and then at the last minute, the week before trial, people are not ready. People want 200 jurors brought down, and then all of a sudden, we need a continuance. So we're going to stop this hearing. We're going to go in recess on this hearing. You're going to call him, and you're going to find out when he's going to have it done.
Yes, Your Honor. But before we stop the hearing,
No, we're going to stop it now because you need to call him and find out when it's going to be done. Because I need to know if he's going to have it done in 2 years or 3 years. We'll pick this up where you left off, but that's the number one question for the court. When is it going to be done?
I will report back.
All right, thank you.
Your Honor, may I be heard on about one matter?
Yes.
Thank you, Your Honor. Additionally, this past week, we were advised that the state's chief witness has actually testified under oath, and that's what I was trying to address. The Court of Criminal Appeals, in a recent decision from last June, held that the transcript of such a testimony is discoverable as soon as is practicable. We've been asking for this kind of stuff for years.
All right,
And
so this
just-
is what I need though, Attorney Goldstein. I
Yes.
need to know when your expert is saying he's going to be done with this.
I understand, but we also need the transcript of that testimony because the Court of Criminal Appeals has been very clear. We can't be compelled to try the case if a chief witness has given prior sworn testimony
All right,
about
so
the same matter.
I
That's all
understand what your attorney is saying, Attorney Goldstein, but what I'm telling everyone, I want to know when your expert says he is going to be done with his analysis. So that's what I need to know right now.
Thank you, Your Honor. We'll get on that and be right back with you on the record in just a moment.
All right, thank you.
Thank you for your patience, Your Honor.
Oh, no problem.